A trust grants an individual legal control over assets they do not own. This separation of legal title and beneficial interest creates a persistent tension, the temptation to prioritize personal gain over the duty to the beneficiary. To see how equity restrains this tension, we will analyze a classic law school problem question. Alice's will creates a trust. She appoints Jemima and Ben as trustees, giving them legal control over assets meant entirely for the benefit of Charlotte and David. The arrangement immediately hits a complication. The trust owns a house with troublesome tenants, and trustee Jemima wants to personally purchase that house owned by the trust. Meanwhile, her co-trustee Ben has secured a director's salary from a company partially owned by the trust. He is also using confidential information gained at board meetings to buy personal shares in a different company. Analyzing these three specific transactions, the property purchase, the corporate salary, and the share trade, reveals the mechanics of strict fiduciary liability. Before analyzing the specific breaches, we must establish the baseline standard. In Bristol and West Building Society v. Mothew, Lord Justice Millett provided the definitive judicial framing. The distinguishing obligation of a fiduciary is the obligation of absolute loyalty. Lord Herschel set the bedrock rule for enforcing this loyalty in Bray v. Ford. A person in a fiduciary position is subject to an inflexible prohibition. They are not allowed to put themselves in a position where their personal interest and their fiduciary duty conflict. Equity enforces this prohibition through strict liability. The goal is entirely preventative. The law deliberately removes the temptation to misbehave by stripping away any possibility of retaining an unauthorized profit. Because the rule is designed to deter, the trustee's state of mind is irrelevant. A trustee's personal honesty, their good faith, or the fact that the trust suffered zero actual financial loss will not save them if a conflict of interest exists. Let's apply these principles to the first legal issue. Can trustee Jemima legally purchase the legal title to the trust's house for herself? This invokes the self-dealing rule. This rule applies whenever a trustee buys trust property. It creates an inherent, unsolvable conflict of interest because the trustee is effectively acting as both the seller, negotiating the highest price, and the buyer, seeking the lowest. Do not confuse this with the fair dealing rule. That applies when a trustee purchases a beneficial interest directly from a beneficiary. In that scenario, the transaction can actually stand, provided the trustee proves it was demonstrably fair and totally free of undue influence. But Jemima is buying the trust property itself, meaning the self-dealing rule applies strictly. Based on the precedent of ex parlacy, the court will completely ignore any argument that she offered a fair market price. Fairness has no bearing on self-dealing. The legal outcome is precise. The sale is not automatically void. Instead, it is voidable at the absolute discretion of the beneficiaries, Charlotte and David, provided they object within a reasonable time. There are only 3 ways Jemima can circumvent this rule. She needs explicit authorization written into Alice's original will, the fully informed consent of all the beneficiaries, or a formal court order approving the sale. Here is an examiner's tip. Never waste exam time arguing that a property was sold at a fair market value when the strict self-dealing rule applies. The fairness of the transaction is legally irrelevant to the breach. We move to the second issue. Ben is taking a salary as a director of Travco, a private company where the trust holds a 40%.
Under re McAdam, we have to run the specific but-for math. That 75% majority in favor of Ben included the trust's 40% shareholding block. To test his independence, we calculate the hypothetical outcome if the trust's shares had been voted against his appointment. Subtracting 40 from the for column and adding it to the against column shifts the final totals to 35% in favor and 65% against. Mathematically, Ben obtained the position solely by virtue of the trust's voting power. He has placed himself in breach of his duty not to profit from the trust, and he must account for every penny of that salary. Another examiner's tip. When evaluating directorship questions, you must explicitly write out this independent vote math on the page. It is the only way to definitively prove whether the position was trust-derived. This brings us to Ben's final breach. While sitting at a Travco board meeting, he gained confidential information about an opportunity in a different company, Eastern Tours, and used it to buy and flip shares for personal profit. fiduciaries are strictly accountable for any unauthorized profit made from exploiting information or opportunities they acquire by virtue of their position. The ultimate unforgiving test of this rule comes from the landmark House of Lords case, Boardman v. Phipps. In Boardman, a trust solicitor used information gathered while representing the trust to personally buy shares in a private company. He acted completely honestly, risked his own money, and through skillful management actually generated a massive payout for the trust itself. Despite this, the House of Lords held the defendants strictly liable to account for their personal profits. The ratio established that the mere possibility of a conflict of interest is enough to trigger strict liability. The recent Supreme Court decision in Rukadze reaffirmed this core obligation of loyalty. It clarified that while a link to the profit is required, the strict but-for test of causation does not apply to evaluating a breach of fiduciary duty. Applying this to Ben, his directorship was gained entirely via the trust's shares. Therefore, the Eastern Tour's information legally belonged to the trust. By using it to enrich himself, he exploited that link and breached his duty. Final examiner's tip for this section: never argue that a trustee's honesty or the fact that the trust itself lacked the funds to make the investment serves as a valid legal defense. Under strict liability, neither fact matters. Now that we have established Ben's liability, we have to address the consequences. What specific legal remedies can Charlotte and David pursue to reclaim the profits he made? The beneficiaries must choose between two distinct legal actions.
They can pursue a personal claim, demanding an account of profits that forces Ben to pay a sum equal to his unauthorized gain from his own funds. Or they can pursue a proprietary claim, asserting legal ownership over the actual assets that now represent that profit. The modern authority on navigating this choice is the Supreme Court decision in FHR European Ventures LLP v. Cedar Capital Partners LLC. The FHR rulings simplify the landscape. Any unauthorized profit obtained by a fiduciary, regardless of how it is acquired, is automatically held on constructive trust. This guarantees the principal the option to pursue a proprietary claim. This diagram maps out why that choice is strategically vital for Ben's case. Ben used the Eastern Tour's profits to buy Hopco plc shares, and those shares have since increased in value. By using a proprietary claim, the beneficiaries legally capture that subsequent appreciation. A personal claim would only recover the original fixed profit amount. Furthermore, a proprietary claim grants the beneficiaries absolute priority over the fiduciary's ordinary unsecured creditors in the event of bankruptcy, protecting the trust capital from being swallowed up in insolvency proceedings. There is only one ultimate defense against strict liability: explicit authorization from the creator of the trust. As confirmed in Armitage v. Norse, a valid exemption clause in the trust instrument can relieve trustees of liability for negligent or careless breaches, though it can never protect them against actual fraud. Without that explicit protection in place, the fiduciary duty remains the highest standard of loyalty known to the law. It is inflexible, it is preventative, and it is strictly applied to ensure that the principal's interests are protected above all else.